That's the recording started. And the live stream has started. So
Okay.
if you could just indicate you're here when I call your name. Miss Dawn Black.
Here.
Mr. Jeff Crowson.
Yeah.
Mrs. Ewanson is away at this point in time. Mr. Jeff Goodall.
Yeah.
Mr. Trevor Mason.
Yeah.
Mr. Richard Menard.
Present.
Mrs. Jenny Nichol.
Present.
Miss Mel Sullivan.
Here.
And Mr. Ian Taylor.
Yeah.
So everybody's present and correct. We've got Mr.
much.
Hunter back as well.
Yeah, I was just going to check that as well. Mr. Hunter is here. Yes, I see him. Great. And Mr. Was it Macmillan?
Mr.
Yes.
Macmillan's here as well.
It's also here. Okay, so we're now moving on to the second of these hearings, which is the MFG Inverurie service station at Blackhall Inverurie. So I apologise for the repetitiveness, but we'll go through the procedure. So we don't have anyone that's declared an interest. So we will move on, and I will just remind the agent and CEO that the board meeting is recorded and published online for public viewing after the meeting. And if I could now ask the Deputy Clerk to confirm the procedure of part one of the hearing for the preliminary matter for the Inverurie site.
As it's the same parties, I'll just go through it quite quickly. Same as before, we're looking at excluded premises. Are the premises excluded, or have they met the test set out in section 1235 of the Act, in that there are persons who are resident in the locality who are or are likely to become reliant to a significant extent either on fuel or groceries from the premises. And to add a reminder that the BP case also indicates that are any of those persons materially disadvantaged if the premises were not to provide either fuel or groceries. So that's the preliminary matter in relation to this one. Once we've dealt with that, I'll talk the board through the procedure for the second part, depending on the decision taken. Thank you, Chair.
Thank you very much. So firstly, can I confirm that Andrew Hunter is present and here to represent Motor Fuel Limited?
Yes, thank you.
Thank you. Are you satisfied that you've received all of the relevant information, and do you feel able to participate in the determination of this matter?
Yes, thank you.
Great, thank you. And can I confirm that Lisa Godini, Licensing Standards Officer, is now present?
It'll be.
Is it you again, Kevin?
It'll be myself for.
Okay.
Yeah, thank you.
Okay, that's fine. And are you satisfied that you've received all of the relevant information, and do you feel able to participate in the determination of the matter?
Yes, thank you.
Thank you. So in line with the guidance you've received in the public participant meeting protocol for licensing board hearings, please can you mute your microphone when not speaking. If your phone permits this, obviously you're in the Teams meeting, so you can. Please do not speak unless I invite you to do so, and please do not interrupt the other speakers. If you do, you may be removed from the meeting. Once you've been asked to make concluding remarks, you are not entitled to speak again unless to answer a question from a board member. Once the board has made its decision, you will be asked to leave the meeting. Obviously, we have another hearing after this one, though. If the board requires to adjourn to deliberate the application, the recording of the meeting will be paused and the board will retire to a separate online meeting room. Please wait in the main meeting room until the board members return and I resume the meeting. At that point, the recording would be restarted. And if you just bear with me, and just so for board members' use, the summary of the applicant's submissions is at page 347 for this particular premises. So if I could now invite the agent, Andrew Hunter, to speak to the application, including the representations relating to the board. Thank you.
Thanks, Councillor Black. So in relation to the excluded premises test, perhaps for convenience of all involved, I'll simply run through the information that I set out in the summary which again would be around about page 150-ish in your papers, I think, judging by the numbers that Miss Stewart talked about.
Page 347.
All right,
there's a separate report for each application.
Okay. So it's I suppose in short compass, it's the same type of report as you accepted in relation to the Peterhead application. The numbers are obviously slightly different because it's a different survey, but just running through the summary of what was there then. So it was June 2024 when the research was undertaken at Inverurie. On this occasion, 500 customers were interviewed, of which 127 customers were treated as local residents in terms of the market researchers defined locality. Of those 127, they interviewed 124 who said they were there as fuel customers, 56 who said they were there as grocery customers, so clearly some overlap in those numbers. In the same way, in relation to the previous report, there's some demographic information about them on page 9 of the market research, and then on page 10 and 11, as before, questions are asked about usage of the premises for the purposes of the statutory test. So of the 124 fuel customers, 66% or 82 of them said that the premises accounted as their principal source of fuel, and 5 customers of the grocery customers said that the premises were their principal source of groceries. I'll simply comment on fuel numbers going forward because the grocery numbers are de minimis. So of the 82 customers who said the premises were their principal source of fuel, you'll see they reside within 0.64 miles of the premises on average. And there's a graphic on page 8 in relation to that. And then in terms of the question of material disadvantage or inconvenience, 74.4% or 61 persons said that they would be disadvantaged to the relevant degree, and there's some open-ended answers about that at the end of the report, as there was with Peterhead. In terms of the analysis, then I've set out that you have 61 out of 127 of the local customers interviewed. So that was 48% of the local customers, and just over 12% of everybody who was interviewed. And for the same reasons as I highlighted in respect of the Peterhead application, I would say that 61 or 48% of local customers is above the de minimis threshold. And we noted from our research there were 2 local premises offering fuel, one around about just under a mile, which is the Tesco at Harlow Road, which will operate a limited service of fuel and pay at pump and shop, I suspect, consistent with what Tesco do. And then there's the BP at Stevenson's, which is just under 2 miles away, which is also licensed premises. So taking that into the round, I'd invite you to find that these premises are not excluded premises based on the market research findings that have been presented to you and as summarised by me. Thank you, Convener.
Thank you very much, Mr. Hunsick. So now can I ask Kevin MacDonald, the licensing officer, to speak to the preliminary matter? Thank you.
Good afternoon again, board. Again, refer to section 123, no premises licence or occasional licences effect to authorise the sale of alcohol on excluded premises. And part 5 of that section provides that premises used as a garage or which form part of the premises which are so used. Again, I'd be looking to put forward that whether or not these are materially disadvantaged or inconvenienced customers. I've also tried to look at Mr. Hunter's questionnaires as to whether or not it makes it clear that they refer to simply the garage or the whole Morrison's premises when they're there. Again, the test is whether or not they're materially disadvantaged or inconvenienced. as Mr. Hunter put in his, no, we'll not go there, sorry. Yes, it's whether or not they're considered, this is a material part of their business. Does it need to be excluded or not? Thank you.
Thank you. So, Mr. Hunter, would you have anything you'd wish to add, having heard a submission of the Licensing Standards Officer?
Simply that if one looks at the questionnaire in relation to these matters and when they're asked about disadvantage, then the questions are directed towards fuel or groceries. So the market research records answers of individuals in relation to their stated disadvantage or inconvenience in relation to fuel, and on the assumption that the customers understand what fuel is, that would eliminate their reliance on the nearby Morrison's supermarket, which doesn't sell fuel.
Okay, thank you very much. Do any board members have any questions they'd like to ask of either party at this time? Mr. Menard, please.
Yes, a question for Mr. Hunter there. During your surveys that you've commissioned there, when you were speaking to, or your agents were speaking to the customers in, I presume that was in the garage itself or in the garage premises itself, were they made aware that at the time of the survey and the questions that it was about your company rather than Morrison's? If you understand where I'm coming from, are they aware that it was no longer a Morrison's owned property? And that's a question I need to clear up.
Yes. So question 12 in the annex, when they're asked questions about disadvantage, there's then a section where the market researcher reads out, now that you've been told about changes that are coming to the site as a result of the purchase by MFG, so Motor Fuel Group, and then so on, this additional information is provided. So they are told that it's a survey on behalf of Motor Fuel Group.
Can I just come back there? Was that before the questions or after the questions?
Can I bring Ms. Stewart in at this point, please?
Thank you, Chair. Before we get much further down this line of questioning, I think whoever runs the premises here, be it Morrison's or the motor group, is irrelevant. That's not the test of who runs the group. The test is, are persons resident in the locality reliant to a significant degree on the premises, not the operator of the premises, as a principal source of fuel or groceries. So I'm not sure I could advise you, Mr. Menard, that those questions are relevant or should be given any weight in determination of this. It's not part of the legal test that you're being asked to consider.
Okay, thank you, Fiona. I appreciate that. It was just, like I say, just the way that the questions were asked and how they were asked that I wanted to get clarification on. Thank you.
Okay, thanks for that, Fiona. Anybody else got any questions? No. Okay, so I will now invite for remarks in reverse order, but just reminding you that no new evidence can be added at this point. Mr. MacDonald, would you like to add anything? Would like to sum up or add anything?
I have nothing further to add, thank you.
Okay, and Mr. Hunter, would you like to sum up?
Simply that in my respectful submission, the information in the market research bears out that more than a de minimis number of persons have provided evidence that they're relying on the premises to the relevant extent, and as such the board can find that the premises are an exception to the general exclusion in terms of section 123(5) of the relevant act, such that the application can proceed to stage 2, and I'd invite you to so find. Thank you very much.
Thank you. Do board members need any legal advice from the clerk at this point, please? I'm seeing no hands. No. And can I ask you then to outline the terms of the legal test for the preliminary matter, please, Deputy Clerk?
Yeah, just to review that in terms of section 1235 of the Act, the test is that there are persons resident in the locality who are or who are likely to become reliant to a significant degree on the premises as their principal source of fuel or groceries, bearing in mind the BP case also says that will those persons be materially disadvantaged if the premises were not to provide fuel or groceries. That is the legal test for this part of the hearing.
Thank you very much. And do board members wish to retire to deliberate this at this point? Okay, I'm seeing no hands. So I'll now ask members to debate, just reminding you that it's only on the preliminary matter that we're debating at the moment. Okay, so I am seeing no hands. So oh, sorry, Mr. Goodall.
I think the circumstances under which we find ourselves are identical to the first one, so I would simply move that we come to the same conclusion and move on to the next piece of business.
Thank you. And Mr. Taylor?
Thank you. I think we've been given considerable amount of information about numbers of individuals using the filling station as a fuel supply and whether they would be disadvantaged or not. And therefore, I feel that this application is going to be exempt from the excluded premises. Thank you.
Okay, thanks very much. I see no further hands, so I would just want to check with members that you feel that you've got sufficient evidence upon which to make this decision.
Yes.
Yes.
Yes. Thank you. So if I could call for a motion at this point then, please. Mr. Taylor.
Yes, I would propose that we accept this application as exempt, given the information that we've been provided with in terms of the numbers of individuals that use the premises as a supply of fuel, and the large proportion of individuals that may well be disadvantaged. Thank you very much.
Okay, thank you. And so we'll be seeking a seconder. Mr. Goodall, are you seconding?
Yes. I shall second on those parameters.
Thank you. Ms. Stewart, can you just confirm that there's enough of an outline there for the motion?
Yeah, I've got enough of reasoning there, yeah.
Okay, can I ask if there's any amendment? I'm seeing no hands, so can I confirm that this decision is unanimous of the whole board then, please?
Yes.
Yeah?
Yes.
Yeah. Mr. Menard?
Yeah, I'm sorry, I'm not unanimous.
Okay.
Prefer or not vote if it comes to it.
Okay.
Okay, so do you wish a roll call?
We'll do a roll call then, please. Yes.
Unless Mr. Maynard's proposing to make an amendment.
An amendment, yeah.
No, I'm not going to make an amendment because I know it wouldn't stand anyway. So, like I say, I just want to make my dissent noted. That's all. Thank you.
Okay, so we'll do a roll call. So if you could indicate whether you're in favour of the motion, if you're against or no voting. Ms. Black.
For.
Mr. Crowson.
For.
Mrs. Ewanson is not present. Mr. Goodall.
For.
Mr. Mason.
For.
Mr. Menard.
Against.
So do you want that put down as a no vote?
Yes, please.
Mrs. Nichol.
For.
Ms Sullivan
For.
and Mr Taylor.
For.
So I can confirm that the board has accepted the premises meet the requirements for the exemption by majority with 1 dissent. And I can perhaps make Mr Hunter and the board's position easier in relation to part 2. We don't have an over-provision policy in Inverurie. The application has met all of our requirements. The applicant has agreed to the relevant local and specific conditions. There are no grounds of refusal to be met. Therefore, you could essentially treat this application now as a non-contentious application and determine it for grant, unless there's any questions you want to put to the applicant first.
Okay. Does anyone have any questions they wish to put to Mr Hunter? No. Okay, so can I confirm that the decision for granting the licence is to approve the licence in that case?
Yes.
Yes.
Yep.
Yes.
Okay. Thank you very much.
Okay. So I'll just
Okay.
confirm the decision, Chair. Mr Hunter, the application has been granted subject to the agreed conditions.
Thank you.
Okay, so moving on, we're going to go through exactly the same process, please, for the North Deeside Road Bankery service station. So I assume that it's Mr Hunter and Mr MacDonald again, yes? Okay, so let's whiz through this, shall we? So initially, I will then ask Mr Hunter if you can please give your submission to the board. Thank you. Mr Hunter?
Sorry, I'm on mute. Apologies. At the risk of doing myself a disservice, I think there is also a letter of objection though in relation to the section 1, 2.
There is one objection, yes, from
Yeah,
the Community Council.
From the Community Council, I think respectfully probably misunderstands the application of the statutory test, but in any event, in terms.
Can I just indicate that the objector has indicated that they will not be present today. If I can confirm that position with our paralegal, Harriet.
That's correct. Fiona, the objector is happy for the original objection to stand alone.
Is the board happy to proceed in the absence of the objector? They are advised that the hearing may proceed in their absence if they don't attend.
Agreed.
Yes.
So on that basis, and I believe that the objection, Harriet will confirm that the objection was in relation to the preliminary matter.
That's correct.
Yeah. So the procedure will be that the applicant's written objection can be considered by the board. I'm sure Mr Hunter will have something to say about the relevance and the weight that can be attached to that. So as to hear Mr Hunter, hear the LSO, consider the written objection. Mr Hunter will have a right of reply, questions to all parties, concluding remarks in reverse order, and then move to the decision. So you've agreed to proceed in the absence of the objector.
Thank you, Ms Stewart. So if I can now bring Mr Hunter in, please, to speak to his submission.
Thanks very much, convener. If I can, what I'll do is, if it's in order, I'll simply run through the numbers for this application, and then I'll comment briefly on the Community Council representation, if that's in order. So in terms of this one, so the market research in this instance interviewed 476 customers, 25%, 122 of them identified as local customers. All of them said the premises were their principal source of fuel. All of them were fuel customers, apologies, and then 90% of them, so 110 persons, said that the premises were their principal source of fuel, and that 110 were residing in an average of 0.7 miles of the premises. From that 110, they were then asked a disadvantage question, or the material inconvenience question, 80% or 88 persons gave an answer in the affirmative that they would consider themselves materially disadvantaged or inconvenienced. So 88 out of 122 is 72% of the local customers, 18% of everybody. And also I said in terms of the numbers in Peterhead, it was unusual to see over 50%. I confess I don't recall seeing reliance in I think with the exception of one location which had only one petrol station, levels as high as 72%. We did our interrogation about other facilities locally. All that we identified was a pay at pump facility at the Tesco, and then the nearest premises after that were a Shell around about 5 miles away. And apologies if I missed anything, but the local community council seemed to identify only one fuel premises in the locality. And I'd simply echo what I said previously about facilities being provided for customers, and I think it's understandable that you would see the level of reliance for the Morrison's petrol station in circumstances where the alternative was a pay and pump facility only, with no other convenience facilities available other than in the main Tesco supermarket. Beyond that, I appreciate the Community Council wouldn't have seen the market research and therefore wouldn't have been able to comment on the numbers, but simply highlighting that on the fuel reliance numbers, I think there's overwhelming support in favour of the premises being treated as exempt. I take on board what the Community Council say about groceries and reliance and availability of other grocery outlets. But I think the overwhelming case is the OR, which in this case is the OR fuel. And I'd simply invite you to find, as you've done in relation to the other applications, that these premises meet the statutory exception to the exclusion. Thank you very much.
Thank you, Mr. Hunter. And so can I ask Mr. MacDonald to speak to the preliminary matter, please?
Hello again, board. Yes, I would just go back to emphasising section 123. It's in regard to excluded premises, and part 5 of that section, it's premises used as a garage or which form part of the premises which are used as such. In respect to Mr. Hunter's figures, I see that his figures relate to just over 1% of the population of Bankery that may be inconvenienced. And that's it. Thank you.
Thank you very much. And if I could ask Mr. Hunter if you have anything you would like to add, having heard the LSO's submission.
Just similar to what I said in relation to the Peterhead application, I think was that the market research is not an attempt to interview everybody in the Bankery area, and I think that would be an unreasonable expectation. So the figures have to be taken in the context of the number of people that were interviewed and the percentages of those interviewed, not as a percentage of an entire population, and that approach would certainly not be consistent with what the court session had taken. Thank you.
Thank you very much. So I'll now invite board members to ask any questions they have of either party. Okay, I see no hands. So in that case, if I can invite concluding remarks in reverse order, but remembering that no new evidence can be put before us. Mr. MacDonald, do you have anything you'd like to add for summing up?
Sorry, nothing further to add, thank you.
Nothing further. And Mr. Hunter, would you like to sum up?
Simply that if the board agreed that the case had been made in relation to Peterhead and Inverurie, it's certainly made in this one where the levels of reliance are far higher. And I'd invite you to so find. Thank you.
Thank you very much. Do more board members require legal advice from the clerk at this point, please? Okay, I'm seeing no hands. So can I please now ask the Deputy Clerk to outline the terms of the legal test for this matter?
For the last time today, I think it'll be ingrained in our brains after this. Section 1235, the test is that persons who are resident in the locality are or are likely to become reliant to a significant degree on the use of the premises as their principal source of either fuel or groceries, bearing in mind the BP case, who also indicated that if there be proportion of persons materially disadvantaged if the premises were not to provide fuel or groceries. So that is the test for the preliminary matter.
Thank you very much. Can I ask board members if they'd wish to retire to deliberate? No, I'm seeing shaking heads. So I can now open it to debate, members, then please. Anybody got any comments or debate points they'd like to make? Okay, I'm seeing no hands. I would say, as I live quite close to Bankery, of all three, this is the one that people are dependent on this fuel station for fuel, absolutely, because there are, as has already been mentioned, only two, and this is the only one where you can pay cash if that's what you want to do, because the Tesco is a pay at pump only. So of all three, this is the one that, you know, people depend on. So definitely would classify under exclusion. Okay, so in that case, if nobody else has any comment to make, can you confirm that you've received sufficient evidence upon which to make a decision?
Yes.
Yes.
Yep. Okay. So if I could call for a motion, is anyone willing to make a motion? Ms. Nichol.
Thanks, convener. Yeah, I think probably worthwhile to thank the Community Council for bringing forward their objection. But yeah, I appreciated the statistics on this one too, especially the high figures for the reliance on fuel. So yeah, I would find that this does meet the criteria for the statutory exemption in this case.
Okay, thank you. And we're looking for a seconder, Ms. Sullivan.
Yep, happy to second.
Okay, thank you. Do we have any amendments? No. Okay.
Can I ask if that's unanimous?
Yeah, that was where I was going next. Can I ask if that's unanimous, please?
Yes.
Yep.
Yeah.
Yep.
No dissent. Okay. Are we content to do that it's unanimous and we don't need a roll call?
Don't need a roll call.
Okay.
And I'm happy to put that down as unanimous, Chair. Exactly the same as the Inverurie store. The Bankery store is not in an area of over provision. It meets all of the criteria that we have set out. The applicant has agreed the local conditions, and again we can treat it as a non-contentious application. And unless there are any questions to put to Mr. Hunter, I would move that the application should be granted.
Okay, do we have any questions to Mr. Hunter regarding the actual alcohol licence, as it is now considered non-contentious? Mr. Taylor.
Just to ask Mr. Hunter, he made great reference in earlier applications about the professionalism of the group and running their stores, and just to ensure that the Bankery one would be similar.
Yes, absolutely. As it happens, the management team behind Bankery, it's a different one from the earlier one discussed, but they are responsible for 3 other sites, all of which are licensed, so they're well experienced in the requirements.
Okay. Thank you very much. Just had the reminder that these are actually provisional licenses, so some of the detail does still need to be ironed out. That 3 that we've been granted, or the 2 that we're granting, are provisional premises licenses. Okay. So are we agreed to grant the provisional premises license? Agreed.
Agreed.
And I take that's unanimous. I'm not seeing any.
Yeah, not seeing
dissent.
anything. No.
So, Mr. Hunter, I can confirm that this application has been granted, And I'd like to thank you for your time, and Mr. Macmillan, who sat very patiently through the hearing as well, for attending today.
Yeah, I would echo that. So, yeah, I would echo that, and thank you very much for persevering through the procedure for all three.
No, thanks to the board. It's if it's any consolation to the members of the board, you get one board, but you hear three of those applications. I'm going through that across the country, so my penance is perhaps greater. But thank you for your time, and I appreciate that, and all the best. And apologies to anyone else who's listening in that's got other applications waiting behind for taking up so much of the board. Thank you.
Thank you very much. I can confirm that the hearing's now concluded, all three of them. So thanks for your interest in this business, and I'll now ask you to leave the meeting. Okay, I think Mr. Macmillan and Mr. Hunter have both left, so that's fine. Okay, so we're moving on now to our next item, which is item 9, I believe, which is the application for a major variation of premises licence for Barra Castle Farm Shop and Cafe in Old Meldrum.
I believe we have David Scott here. Can I just confirm that you're here, David?
Yes, I am here indeed.
And Lisa, are you the LSO taking this hearing? And you're definitely here, yes.
I'm definitely here, thank you.
Good.
I think
Great.
Chair Harriet wants to come in.
Okay, sorry, Harriet, yes.
Thank you. Sorry, just very quickly, it was indicated that the applicant, Sarah Stephen, was also to attend. Just wanted to double check with David Scott if his client is looking to dial in. Don't have anyone just now.
No, she said she was going to be listening in, but I don't think she has dialed in.
Perfect. Okay, thank you.
Okay, that's fine. Thank you, Harriet. So can I confirm, Mr. Scott, that you're satisfied that you've received all of the relevant information and you feel able to participate in the determination of this application?
Yes, indeed.
Thank you very much. And Lisa Godini, the LSO, can I ask if you are satisfied that you've received all the relevant information and you feel able to participate in the determination of the application?
Yes, I'm good to go.
Thank you. So in line with the guidance you've received in the public participant meeting protocol for licence board hearings, please can you mute your microphone while not speaking? And please do not speak unless I ask you to do so. And please do not interrupt other speakers. If you do, you may be removed from the meeting. Once you've been asked to make concluding remarks, you are not entitled to speak again unless to answer a question from a board member. Once the board has made its decision, you will be asked to leave the meeting. If the board requires to adjourn to deliberate the application, the recording of the meeting will be paused and the board will retire to a separate online meeting room. Please wait in the main meeting room until the board members return and I resume the meeting. And at that point, the recording of the meeting will restart, as will the live stream. So if I could ask the agent, David Scott, to outline the terms of the application to the board and to address why the board... Sorry, yes?
Sorry, can I just come in first, please? That might actually help with matters. The only reason that we're at a hearing for this major variation today is there are some of the local conditions that the applicant's agent has not been able to agree to. For valid reasons, and the LSO has actually recommended some alternative wording to replace some of the local conditions. These relate to the beer gardens and outside drinking areas. It's due to the nature of the operation, particularly in relation to weddings at the venue and the outside lawn area. There are set local conditions in the policy. Officers don't have authority to grant departures to policy. Therefore, we don't have authority to agree to the alternative conditions. So everything in this application is being processed is fine, and the standard local conditions have all been accepted with the exception of the outdoor areas. We're recommending that the local conditions be departed from, and that we accept the alternative wording set out by the LSO, which I believe Mr. Scott has agreed to. So it's purely the departure to policy here. There are no grounds to refuse this application. So that's the sole ground and sole reason for the hearing today. And as you quite rightly have found the procedure, Chair, I'll hand you back now to let Mr. Scott speak to the matter at hand.
Thank you very much for that clarification, Ms. Stewart. So I can ask you, please, Mr. Scott, to outline the terms of the application to the board and address why the board should grant a departure to local conditions in order to grant the application at this time. You will get another opportunity to address us after the other parties have spoken. Thank you. If you go ahead.
Thank you, Convener. I think it was very helpful for Fiona Stewart to add her input at the start of that as to why this has come before the board. If you don't know Barra Farm and Barra Berries, it is just outside Old Meldrum. There is an existing farm, shop and cafe that was granted a license a number of years ago, and they operate both indoors and outdoors. They have a patio area to the front of Barra Berries, and as part of their application for their premises license, they were granted approval to open the outdoor area until 11 p.m. So that is the first part of this where we're looking at a slight departure because we have an existing premises license that does provide for outdoor drinking up to 11 p.m. As part of the development of Barra Berries, they have opened up Barra Barn as a separate exclusive use venue to the rear of the existing cafe and farm shop. Now, Barra Barn has been operating now for some time under a series of occasional licenses, and they mainly attract weddings, although they do attract some other functions as well, whether that be conferences or other private exclusive use events. So this is taking place in the barn as it stands, and the purpose of this application is to extend the existing premises license to cover the additional area formed by the Barra Barn and the lawn in front of the barn as well, which is often used for wedding events and gatherings before people retire indoors. So really the point of this application is just to encompass it all into one premises license, including the shop, the cafeteria, the outdoor patio area that already exist, and then the additional area comprising Barra Barn and the lawn outside Barra Barn area. So the three conditions that we are looking at that, I mean, as Fiona said, we are not agreeing to. It's not that we're not agreeing to them, but I suppose the situation is that we have a premises license already, and this has slight variations on those conditions in terms of the use of the outdoor area, and in terms of children, and in terms of music and recorded music at the area. So that's really what we're looking at here. The first point, I suppose, then is the timings of the outdoor areas. As I say, the existing outdoor area at the front of the farm shop allows occupation up until 11 p.m. The current policy of the board is that any outdoor area should be 10 p.m. In extending the layout to include the lawn area in front of the Barra Barn, we're simply looking for the same provisions to apply to include that up to 11 p.m. rather than have any sort of potential conflict where the front patio area is open till 11 a.m. but the rear area behind Barra Barn is 10 p.m. So it's just to maintain that consistency. The second point, which is local condition 34, currently that doesn't apply to these premises. This is relating to amplified music or noise emitted from microphones. Again, we've had a discussion with the LSOs, and the LSOs are happy to provide alternative wording to local condition 34. Again, their view, given the particular nature of this, we're talking about exclusive use events for weddings, and the idea that you might have a guitarist or a quartet or some other form of background music that might be playing during an outdoor part of any wedding that might take place at Barra Barn. So it's simply to allow that outdoor music to continue in this lawn area in front of in front of the barn itself. Now, the idea would be that this is not about performing gigs or events there. It's simply background music for weddings. And, you know, as we say, we're happy with the proposed policy that's come from the LSOs. The third local condition in relation to this application, which didn't previously apply for good reason, is that is local condition 35, and that relates to children and young person. The actual local condition says that they should be permitted in the cafe, beer garden or outside drinking area for the purpose of consumption of food. Now, this is a wedding venue. There may be food served, but it might not be at all times, and it's not the sole focus of the venue itself. The venue is a wedding venue, and it was just to make sure that children can be in attendance at any wedding event or function within that lawn area, despite the fact that they are not necessarily consuming food at that particular point in time. Again, this is just consistent with the existing premises license, which does not require the consumption of food for any children in the outdoor area at the front of Barra Barn, and it's to take that consistency through to the rear of the premises as well. Like I say, I think there are specific reasons why you would expect that to be the case, even more so at a wedding event rather than necessarily just in a cafe, just because of the nature of children being in attendance at a wedding, and perhaps after the ceremony takes place, glasses of Prosecco are poured. So in terms of the licensing policy, we are looking for the board to consider these exemptions or departures from the existing policy, but that's on the basis that we have an existing premises license that provides for this. We're looking for that consistency to apply to the rear of the premises in the lawn area, in addition to the front patio area as it stands, and particularly the nature of Barra Barn as an exclusive use venue, predominantly focusing on weddings. And we think that these amendments to the local conditions are all entirely reasonable, and we have the support of the LSO in that request as well.
Okay, thank you very much. Can I ask Lisa Godini to speak to her representation? Thank you.
Yeah, thank you very much. So my representation relates to local conditions 31, 34 and 35, which all relate to the outdoor areas of a premises. I have considered the application as well as the local conditions set out by yourselves, and feel that in this instance it may be appropriate to discuss departure from policy, however with some restrictions still in place. As mentioned, the current premises licence has an external terrace area to the front of the farm shop, and condition 31 is currently attached to the premises licence. However, as this was applied to the licence prior to the policy review, which took effect from November 2023, the area can be used for the sale of or consumption of alcohol until 2300 hours. This variation application is looking to add an additional external area adjacent to the barn, and given the location of the premises and the outdoor area, I am proposing that the terminal hour for the additional space aligns with the current space, with the terminal hour of 2300 hours and not 2200 hours as per the current condition. In addition, conditions 34 and 35 are not currently applied to the premises licence, as they were conditions which were added to the pool of conditions following the review of the policy in 2023, with the premises licence being granted prior to this. I have considered both of these conditions and believe departure from policy may be appropriate in this circumstance. Given the main use of the event space and external area is to facilitate weddings, although not exclusively, I would like to recommend local condition 34 is reworded to allow the use of recorded music or unamplified forms of live music in the outdoor area, providing it is background music only. I would also be of the opinion that condition 35 is not appropriate for the outdoor space beside the barn. Condition 34 states that the licence holder shall ensure that no amplified music or noise emitted from the use of microphone speakers or other forms of music entertainment shall be played within the area. The area is to be delineated by a physical barrier, and signage is displayed indicating that alcohol is not to be removed from the area. Condition 35 states that children and young persons may not be present in the outdoor drinking area may be present in the outdoor area for the purpose of the consumption of food. If the board are minded to depart from policy in relation to condition 34, I would recommend specific conditions be applied in order to maintain a level of control over the use of the outdoor space. These are as follows. 1. The licence holder shall ensure that the use of recorded music or unamplified forms of live music is permitted in the outdoor areas, providing it is background music only. 2. The licence holder shall ensure that no amplified music or noise emitted from the use of microphones, speakers or other forms of entertainment shall be played within the outdoor areas. And 3. The licence holder shall ensure that background music shall not be played in the outdoor areas after 2200 hours. Thank you.
Thank you very much, Lisa. Mr. Scott, do you have anything you'd like to add, having heard the submission from the LSO?
No, we're happy to agree to the alternative amended wording conditions that Lisa has provided. I think, as she said, the location of these premises means that they are, they're some distance from any neighbouring properties, and in terms of any kind of nuisance caused by this, we're looking at background music only, and the distance from any impacted properties is so significant that we agree with the approach taken by the LSO.
Thank you very much. Just for the benefit of the board members, all the suggestions as outlined by the LSO are on 3.12 of our reports, which is on page 509, if you need to reference them. So I'd now like to invite board members to ask questions of all the parties, please. Anybody got any questions? Mr. Scott or for Lisa? Okay. Yes, Mr. Mason. Trevor, you're muted.
Sorry about that. Yeah, the distance, it does seem quite remote, the castle itself and the area around. How far is it to the nearest property? Do you know, Mr. Scott?
From the rear side of the barn, looking in that direction, it's around 500 metres to the nearest residential properties. There are some properties on the other side of the road which are potentially 200 metres away, but these are already ones which are, I suppose, on that side of the building. That's the side that already has the licensed patio area until 11 p.m.
Yeah, so it's still quite a distance away, really. Yeah.
Still quite a distance, yes.
Yeah, thanks.
And there are holiday lets within the grounds of the castle, but they're all owned by our clients.
Okay, thank you very much. Anybody else? I'm seeing no hands. So if I could ask the LSO, Lisa, if you'd like to say anything in closing. Please note you can't add any new evidence at this stage.
No, I've got nothing else to say. Thank you.
Okay. And Mr. Scott, do you have anything you'd like to say in closing, noting that you can't add any new evidence?
No, I think I'm happy with what we've said before, and on the basis there hasn't been anything new risen in any questions, then happy to close it at that.
Okay, thank you very much. So do board members require legal advice from the clerk, please? Anybody? No, seeing no indications. So if I could ask the Deputy Clerk to outline the terms of the legal test for the application, please.
So the legal test is that there's no grounds of refusal, but what's been agreed to and what you've heard today between the applicant and the LSO is that condition 31 will be amended from 10 p.m. to 11 p.m. to match the existing licensed area at the front of the premises. Conditions 34 and 35 of the local conditions will be removed, and in place of that, the specific conditions set out at section 3.12 of the report will be added in lieu of that. So you'll see there that covers portable wash hand facilities, food safety, and specific conditions in relation to the outdoor drinking areas. So if the board's agreeable to that departure to policy, that's what would be attached to the varied licence if you grant the variation today.
Okay, thank you very much. Do board members wish to retire to deliberate this one, please? No indications. In that case, I would open it to debate for board members. Anybody? Anything to discuss? Mr. Goodall.
Just to say, Mrs. Black, that what I've heard seems perfectly reasonable. I have no objection to anything that's been presented before us, and I'm not putting a motion forward at this point, but yes, I'd be quite happy with this as it sits. Thank you.
Thank you very much. And Ms. Sullivan.
Everyone agrees, which is where we like to get people to. So can I present some?
We have got another
right.
hand up, so
No
I will
motions.
come. I'll come back to you, Mel, if that's okay. Mr. Menard.
No, I'm actually very happy with the way that this has all been presented, and I think we could go with the proposal to well, somebody to propose that we depart from policy on this one. So
Okay.
yeah, I'm happy with that.
Thank you very much. We'll just go through the procedure. So can I just confirm that everyone has received sufficient evidence upon which to make the decision?
Yes.
Yes.
Yes. Yes. Fantastic. So at this point, Miss Sullivan, I'm happy to call for a motion. Would you like to propose?
I would love to propose a motion to, what am I proposing for? Departing from local conditions in line with what the LSO has suggested?
Yeah, you're recommending agreeing to the amendment of condition 31,
yes.
Removal of conditions 34 and 35, and attachment of the specific conditions set out in 3.12 of the report, which have been agreed between the applicant and the LSO.
Exactly that. Thank you very much.
Thank you. And calling for a seconder, Mr. Maynard.
That's very happy to second that. On exactly the same grounds. Thank you.
Yeah, thank you very much. And do we have any amendment? No, fantastic. So if I can just confirm that that's a unanimous decision.
Yes.
Yes. Okay, super. So I'm quite content that we don't need to take a roll call for that one.
No. So,
no.
Mr. Scott, I can confirm that the application has been granted today with the departure to local policy as your clients require. And thank you for being patient today, and thank you for attending the hearing.
Not at all. Thank you to all of the board, and particularly to the LSO and to Harriet for all the work they've done in getting the application to here. So thank you.
Absolutely. Thank you very much. Okay, I confirm that the hearing's now concluded and ask you to leave the meeting. I think he is gone. That's great. Okay, so this is the end of the morning session. So it is now 1:10. What I would suggest is that we do break for lunch now to give us plenty of time because it's a long day today. And if we could end the morning live stream and the recording, we will reconvene at 2 o'clock, please.
I'll just confirm that the recording and the live stream have stopped.